Hello, my name is Julie Esposito, and I'm an attorney with the Ensberg Law Group in West Covina, California. I'm here to talk about the California civil litigation process and why you should avoid it if you can. As an attorney here in Southern California, I'm often asked by people who have been wronged or have suffered some financial setback at the hands of another if they have a court case. They will start by telling me some way they have been wronged and ask me who they can sue and how to do it. Well, here's the deal. Not every offense that is done to us is actionable in a court of law. For most of us, that is a comforting fact. But even when you do have a case, whether or not you should run out and file a lawsuit requires a careful cost-benefit analysis. Litigation is expensive. Only some lawyers work on a contingency basis. A contingency case is one where you pay a lawyer a percentage of the amount you recover at the end of a lawsuit or after a settlement. Generally speaking, lawyers who will take your matter on a contingency basis will do so only if you have a particular kind of case, such as a personal injury or employment discrimination case, and they think your case will be lucrative. But even then, the outcome is far from certain. You have to deal with a host of factors often beyond your control, such as available evidence, the judge, even the jury pool. And litigation is expensive not only monetarily. Litigating is time-consuming. A case can take months, even years to resolve. For a lot of people, the process can be very stressful and emotionally draining, so it can be personally costly. Nonetheless, sometimes litigation is a necessary evil, particularly where you are the defendant and have been sued. In that case, the first thing you need to do is determine whether you have any insurance available. But that is another talk. For now, here's what to expect during the course of the litigation process. Remember, your case can and hopefully will settle at any time during the continuum, ending the process. First, the plaintiff files a complaint setting forth all causes of action against the defendant. Causes of action are legally recognizable claims for which the law provides a remedy. The relief sought can be monetary, non-monetary, or both. Non-monetary relief includes things like injunctions or declaratory relief, such as where you are asking the court to determine the ownership rights of a piece of property. A summons is then issued by the clerk of the court, which names the defendants. Any defendants whose identities are not yet known can be named as DOE defendants for now, to protect any applicable statutes of limitations. However, the plaintiff has to diligently seek out the identities of these DOE defendants, or the court will dismiss them at some point. Within 60 days of filing the complaint, the plaintiff has to make sure that the summons and complaint are served on the named defendants. Once served, the defendant must respond to the complaint within 30 days. The parties will then start what is known as the discovery process, which can include written questions called interrogatories, demands for the exchange of documents, depositions, and witness subpoenas. This all needs to be done so that each side can see the other side's case and get ready to try to settle the matter or head to trial. At some point, the court will set a case management conference, at which time the judge will ask the lawyers about the case. The judge may set the case for trial right then, and/or may refer the parties to mediation or arbitration, depending on what the parties agree to. The parties will tell the court whether they want a judge trial or a jury trial. Parties wanting jury trials have to post jury fees immediately. The judge will sometimes set a trial date far enough ahead so that the parties can try to settle before then. The parties will tell the court whether they want a judge trial or a jury trial. Parties wanting jury trials have to post jury fees immediately. Once the trial date is set, certain deadlines are set, such as discovery cutoff, expert exchange dates, etc. Again, litigation is expensive. Not only are you paying for your attorneys, you are probably paying for expert witnesses to be retained. Expert witnesses need to do work on your case, have their depositions taken by the other side, and testify at trial. Then there are costs. Costs are filing fees, copying, subpoenas, and depositions, among other things. Again, even if it means paying a mediator to assist you in settling the case, you may be better off than going all the way through a trial. If you have gone all the way through a regular civil trial to judgment, be aware that either side may appeal a final judgment. An appeal can extend the case for at least another year. And again, appellate litigation is also very expensive. The other alternative is proceeding through small claims process. Again, a topic for another talk. If you are an individual or sole proprietor, you have a $10,000 limit. If you are suing on behalf of a corporation or other entity, you have a $5,000 limit. If your claim fits within these parameters, this may be a better option for you. While you are not allowed to have attorneys represent you at a small claims trial, you certainly can hire lawyers to assist you in preparing your case. Notwithstanding everything I have just said, the fact is that sometimes litigation is necessary. You may have a lot at stake, and/or you cannot obtain the cooperation of others or obtain the relief to which you are entitled any other way than by filing a civil lawsuit. If that is the case, be sure to contact a lawyer sooner rather than later to maximize your options and chance for success in your potential lawsuit. I hope you have found this summary of the litigation process helpful. We also hope here at the Ensberg Law Group that you will call us first should we be able to help you with your legal needs, no matter what route you are contemplating.